welcome, Mr. Mike Kofahl. Mike is joining us from Cape Breton today in Nova Scotia. Mike is a staff lawyer at East Coast Environmental Law, a partner and co-convener of this symposium today. His work focuses on coastal and marine environmental law and policy. Mike's interest in coastal access stems from his legal research on coastal protection and management law and his advocacy today and for years since now, and for stronger laws in Atlantic Canada for the coast specifically. Mike has produced some really amazing resources in the past few years, public legal education materials, reports about coastal access. You can find those in some of our resources in the program today. And he does some really amazing community work, delivering community workshops all around Atlantic Canada that explore how coastal access intersects with other areas of coastal governance. So with that, I will hand it over to Mike. Mike, welcome, and thank you so much for kicking us off this morning.
Thank you for that introduction. I am indeed Mike Kofahl, a staff lawyer at East Coast Environmental Law. And I thought I would talk today about the intersection between public coastal access and environmental law, because I am a public interest environmental lawyer, and there is quite a interesting intersection between those two things. And sometimes when I say I'm an environmental lawyer and then I also work on coastal access, people question or ask more about that connection. So I'm going to chat a little bit about that. I do actually have to minimize this because I can't see. Okay. So just quickly about East Coast Environmental Law. We are a nonprofit environmental law charity operating throughout Atlantic Canada, and we envision a future where laws and legal systems really protect ecological health and also promote environmental and climate justice. And we really do our work through various means. We do public environmental law advocacy. We work on law reform. We provide public legal education and create resources, and we try to share our skills with folks and communities throughout the region. Now, I didn't really want to dive straight in. There we go. I didn't really want to dive straight into the law and the texts and the definitions. I thought that was a little bit much to start us off in the morning. So I thought I would contextualize some of our work and give you the background of how this all started, at least for me. So about 8 years ago, Nova Scotia had a provincial election, and one of the parties, the Liberal Party of Nova Scotia, decided that they would make a promise to create a Coastal Protection Act. They won that election, and they started creating a Coastal Protection Act. And our first question was, well, what does a Coastal Protection Act even look like? At that time, and to this date, Canada doesn't have any dedicated coastal protection laws dealing with coastal protection, dealing with stewardship or access. And so we had no idea what this could potentially be. And we decided to do a jurisdictional review. We looked at Atlantic Canadian provinces, and we looked outside of Canada to places in the United States, to the UK, to Australia, and to New Zealand to get a sense of what is out there. And one of the things that became quite clear for us is that as part of this international attempt to deal with all of the things like sea level rise and erosion and storm surges, and these really intricate and interconnected coastal protection legal regimes, coastal access, public coastal access, was a really important component of that. And so, for example, some jurisdictions have legislation that actually requires coastal access points or coastal trails to be created. They are obligations on government. There are protections for existing rights of access, which actually includes physical access to the coast, movement along the coast, and even sometimes a view of the coast, as in the case of California. There are also sometimes requirements to consider no net loss of public access in decision-making, or to factor public access in decision-making, approvals, permitting for things like development. So it's quite the range. There's quite a range of law dealing with coastal access and public coastal access, but it is a really important part. Now in Canada, we don't really have the same thing. in Canada, and especially in Atlantic Canada, there is no dedicated coastal legislation, as I mentioned, and there's really silence in the law in terms of public access. And effectively, there is no right to public access to access the coast. And this is really interesting because the coast is quite a public space. So, just a caveat here, I'm going to be talking from this point on almost exclusively about Crown law. And I do want to acknowledge that in Atlantic Canada, we are in fact on the territories of many Indigenous nations who've been here for a long, long time, since time immemorial, and have their own connections, relationships, uses of the coast and the coastal resources that are there, and have enduring laws related to their relationship to the coast. But as a lawyer licensed in Crown law, I will focus on that Crown law aspect. And in settler colonial law in Canada, that that coastal space is really divided um, between the high water and low water mark. So from the mean high water mark to the low water mark, that is, by rule of thumb, provincial crown land. So it's public land. And then from the low water mark out to sea, that is also crown land, federal crown land. And so you have this space that's below the high water mark that's effectively all public. And so, although there's no statutory or common law right for the public to access the coast, the that crown law on the coast is actually commonly open to the public to use and access. If you can get to it, you're technically allowed to be there, unless there are some sorts of legal restrictions on accessing that land. And there are laws that potentially create points of access for the coast for the public. So, for example, we have legislation in Atlantic Canada and federally that creates parks or creates recreational areas. In Nova Scotia, we have a law, the Beaches Act, that can be used to designate beaches, including above the high water mark on private land. Legislation that creates wilderness areas and protected areas, and legislation that can be used to create roads and trails along the coast that can facilitate public access. And we also use a mixture of legal tools and approaches like easements. We can enter into licenses and agreements that enable the public to use crown land or private land to access the coast. And we use all sorts of kind of ad hoc or fragmented legislation and statutes and policies to try to create these pockets of coastal access. But what we don't have is a coordinated strategy or vision for what coastal access means when it comes to legal rights and protecting access that already exists. So I'm just going to share, at the time I have remaining, two examples, two stories about how coastal access has led to changes, or stories that highlight the difficulty of where we are right now in Atlantic Canada. So the first example I want to point to is Point La Roche. Point de Roche is a part of the coast on Prince Edward Island, which is the smallest province in Canada. So what you're seeing here on the top photograph is a development in progress. So where there's kind of the foundations for multiple buildings, and there used to be an old farmstead there, a smaller building, probably not much bigger than one of those trailers pictured there. And so this property changed hands, and the new property owner decided, I'm going to build something bigger. So they sought approval from multiple provincial departments for various approvals required under the Planning Act and the Environmental Protection Act in the province. They got those approvals, and they started making this big monstrosity. They tore down the old building, they started creating several new buildings, and they made this giant rock wall. And so members of the public who were quite avid hikers and walkers and used the coast regularly and traverse along that long beach there were walking one day, and they came across this massive rock wall that was impeding their ability to move along the coast, along the beach there. And so it raised quite a number of alarms, and it caused quite a bit of uproar in Prince Edward Island. Um, as a result of these hikers seeing this structure, there were complaints made to provincial representatives and enforcement officers, and this received a lot of local and regional and even national news media and attention. And I'm highlighting this as an example of why coastal access is important. And I'll return to this theme kind of again and again. Um, but coastal access here is quite important because if you're not on the coast, if you can't move along the coast, you can't observe and monitor developments like that that are occurring on the coast, it's actually quite difficult to enforce environmental laws. Based on the experience that we have at East Coast Environmental Law, a lot of complaints that go forward to provincial departments and that end in enforcement action or end in legal action actually start with community members. And so if community members can't be on the coast, it makes it really difficult to start those sorts of actions. This is also a really, I think, inspiring example of people valuing the coast, valuing their access, and taking action as a result of that. So, as a result of the news attention and the focus on this development, the province actually placed a moratorium on new coastal development in Prince Edward Island. And there was a report in 2023 that was commissioned by the province related to coastal management at a more general, broad level. And it included a recommendation to create a law or policy for public beach access. And the province agreed to that commitment. And now there is work being done to create lawful public beach access. The second kind of story I wanted to share is related to West Mabou Beach Provincial Park. The West Mabou Beach Provincial Park is located on Cape Breton Island, which is on the northern part of Nova Scotia. And it's been designated under the Provincial Parks Act in Nova Scotia, I believe, for 26 years. It's designated in a regulation. It has all sorts of protections and prohibitions and restrictions on what you can do there. And West Mabou Beach is also a really popular spot for people to access the coast. It's a beach. It's a beautiful beach. I think there's over 400 acres of land. There's over 10 kilometers of hiking trail. It's people go there to swim, to bike, to walk, to take in the wildlife. It's habitat for example, endangered piping plover. So it's a really special spot, and it's also a really important draw for tourism. Tourists flock to Mabou, and Mabou is also famous for fiddle music, but they're also famous for beautiful beaches. And so this is a really important community space, a really important public space, and a really important space for accessing the coast. And now there have been several attempts over the last, I believe, 6 or 7 years. There have been 3 attempts by a developer, and specifically a golf developer, to purchase this land from the province, have it delisted, designated, and turn it into a golf course. And so I think maybe a year and a half or two ago, the developer made their third attempt at purchasing this land. There was negotiations and discussions with the province, and eventually there was public outcry every single time. There was a lot of pressure on local representatives and the government. This image actually is a sign that is there. There's a couple of these signs. I live quite close to this beach actually, and there's signs all along the road, Save West Mabou Beach Provincial Park, because there's an uproar about these protected spaces that include access, and then having conversations about getting rid of those spaces and making them private and developing them. And these are quite limited. We don't have a ton of these kind of protected beach access points in these public spaces. I will say that as of right now, the government has said, no, we are not going to entertain the thought of development, but it raises the question, if the developer can keep coming back two, three, maybe four times to these spaces that are meant to be set aside for the public's interest and the public good, and that serve as public access points. How strong are our environmental laws that they're not preventing that sort of conversation taking place in the first place? Which brings me kind of to the key takeaways. I hope I'm doing all right on time here. So the first key takeaway is that an ad hoc or fragmented coastal governance approach, which doesn't actually address in any real way public access, can pose a risk that decisions are made that potentially adversely impact the limited existing public access points and access spaces. So, for example, in PEI, multiple decisions were made about approvals and permits for a massive development that then had the impact of restricting public access. And then the second key takeaway I would leave you with is that public access to the coast enables better coastal protection, better management, better stewardship of the coast, because it allows the public to create a connection, to build a relationship, to deepen their valuing of the coast, and to participate in that monitoring and that enforcement action, and enable them to take action and feel like they have a stake in decision making that relates to the coast. So with that, I'm going to end it, and thank you for listening to me talk about the law at 9:30 in the morning, and 5:30 in the morning in California. I'd love to hear from folks, questions, and please feel free to reach out to me if you have questions or want to chat further about this or would like more resources. And I'm trying to find the end share.
There you are. Well done. Thank you so much, Mike. I also am not someone who would probably dive into law early in the morning, but I will say it's a nice way to get us started with thinking about some of those legal frameworks. I'll invite our listeners, if you have a question for Mike or would like to make a brief comment, please feel free to raise your hand in the hand raising tool or to put your comment in the chat. I'll note that I did list in the chat the East Coast Environmental Law Resource Library. It's a really excellent and very accessible, and by that I mean readable, legible, resource library that's intended for general audiences. And there's two things in particular that I've also made a specific link to. One is the coastal access resources for PEI, Prince Edward Island, that you've just heard about, and the other is for Nova Scotia specifically. Both really excellent resources, and I think have gone a long way in helping these community groups that you mentioned not have to reinvent the wheel every time they're dealing with a coastal access issue, which definitely has been a challenge in our province. Um, while we look and wait for any questions or hands, Mike, it really struck me in your talk the issue of being able to monitor the coast and how important access is to that. I wonder if you could like give us an example or tell us a little bit about instances where you've seen that arise in your work where a community member is making an observation that leads to something more serious.
Yeah, so I mean, the PI being one of those examples where there was a positive outcome as a result, but I mean, we have gotten inquiries from individuals, communities, in Nova Scotia and other provinces in Atlantic Canada where typically it's a development like a rock wall or an extension of an existing structure or an expansion of a structure where it's pretty in a pretty precarious place to start with. Maybe it's a development that was put there 50 years ago, and sea level rise and erosion and all of the natural things that go on the coast, it's starting to edge closer and closer and closer. And so they want to protect that space. But as a result, they're actually potentially trespassing on public space by putting physical structures in that space. And it's often community members nearby who use the beach to walk their dog, or there's a trail that exists, and suddenly they're not able to do that anymore. And there's several cases that have appeared in courts where that issue of access, the issue of development being potentially inappropriate, has been raised in court. Um, there's a live issue right now in the Halifax Regional Municipality, which is the largest municipality, largest urban area in Atlantic Canada, where the municipality had entered into or has an agreement with a private property owner. And recently, the municipality decided not to allow infilling on that property, which includes submerged land. And as a result, the private property owner has put up, they were by their agreement with the municipality, they've agreed to create a public access trail along the coast. It runs along the coast. People use it to as a transport corridor. They use it for hiking and all the things you would expect in a public coastal space. And they put up these big signs now that say no trespassing private property. And that is again before the courts, and this really jarring. Like, well, as a public member of the public, what can I do? What stake do I have? And it raises this really interesting challenge of what is the standing of the public to go after and enforce these rights, which aren't set out in statute or common law. They're really set out in maybe a private agreement, or they've been just kind of a long-standing practice of people using that space. Sorry, that was a little bit of a ramble.
No, no, that's perfect. I mean, exactly. The case you've just mentioned, is Dartmouth Cove, if I follow you
Hmm.
correctly. Is that right? Yes. So I'm going to actually put in the chat two links specifically to that issue. This is kind of a fun current event if anyone is interested
Fun.
in oh yeah, fun in what's going on in Nova Scotia. One, and there's two links here. One is from the developer, the one Dartmouth Cove, and the other is from a community group that is uh, expressing a lot of activism and concern about the proposed work of the developer. So you can see both of those there if you're interested. It's a quite I think a really like prime example of some of the issues you're raising. There is a question in the chat that I wonder if you could address. Sam asks, is there a possible path to a less fragmented coastal governance approach in Nova Scotia, perhaps based on examples of what other jurisdictions are doing?
Yeah, there is. There's lots of great examples out there. I mean, the one I always refer to because it's been around for so long and it is quite detailed is the California Coastal Act. But there's lots of great examples of outside of Canada of dedicated coastal protection and management regimes, whether it's a standalone law or a set of laws. Sometimes it can be like a statewide or a countrywide policy that requires local governments to implement certain policy objectives or goals or set certain conditions around coastal protection, but also coastal access. So there is a ton of examples out there. The jurisdictional review that I mentioned, we did it in 2018, and we've just updated that. So there's some really good examples there of various kinds of approaches to doing that because there's not one best fit. And it typically involves kind of a high level coordinated approach to coastal management that's then implemented by local government or regional governments or sometimes dedicated bodies. So, for example, in California, and I know there's other speakers going to speak more about California, but like a dedicated agency.
Yeah, I think thank you, Sam, for the question and for that response, Mike. I think there's another interesting way of looking at some of these things, which is like you mentioned about this public good and whether we have a right to our coast. And we, in this province anyway, don't have a right to get there, even if we have maybe an implied right to be there on that crown land, as you mentioned. But we do have examples in Nova Scotia, and certainly I think the UK is a really interesting example of this. I'm hoping we hear some more about that today of sort of these right to roam style laws of access that give the public rights to access even private property for particular uses. And we do actually have an example of that in Nova Scotia with our Angling Act that allows for the crossing of uncultivated private and crown property for the purposes of fishing rivers, lakes, and streams that, freshwater, obviously, does not apply to our marine coastline. So you can kind of fish right up to where the river enters the sea, maybe.
Yeah.
And it is only for the purposes of angling, for this recreational, legal recreational angling, does not include, say, like the access for a canoe, for instance. You would still want public property for that. So there are some, I think, other interesting legal routes by which those things can be pursued, but that, at least for us, don't exist on the books right now. I know we're going to hear great examples, as you mentioned, from California later. I wonder if there's been much exploration of options like that. And the other one that comes to mind is public trust doctrines, which we see at use in the United States occasionally, but doesn't seem to be the case here. I realize I'm asking you now to speak extensively about the law, if you might be able to reflect a little bit on how some of those things work here.
Yeah, well, I mean, there's definitely the public trust doctrine is applied differently in the United States, and there was a quite famous case, I think, I mean, famous for lawyers, in the 1800s that talked about the public interest doctrine, and then it's applied state by state. So some states apply it quite extensively, some don't. There has been some attempts to apply the public trust doctrine here, which essentially holds that the government holds public spaces in trust for the public. But courts have interpreted it a little bit differently, and it's not been applied in Canada so far, to the same extent, at least, as it has been in the United States. In terms of things like the Angler Act, like there's lots of laws that enable potentially some access. I mean, there's the ability to create trusts or to create easements. And often the case is you run into these situations, these conflicts between private property owners and the public, and this conflict between even like private property owner rights of access. There are riparian rights of access that private property owners have. And that conflict between the private and the public good and private and public rights is always a contentious one. And it's not great when you're going to court to litigate these things. It's a huge waste of time, in my opinion. It's extraordinarily complicated, and usually the outcome is something that no one appreciates. Um, I mean, we have examples in Nova Scotia of local governments taking charge, so dedicating spaces for the public or implicitly dedicating that for the public. So making space, buying property, and then having it available for the public to use. So that's a different way of going about it, using those legal tools that are available, creating those easements without getting into that conflict with the private property owners.
Yeah, it really seems, at least here, quite a patchwork of means of access. We have one more question in the chat before I let you go. Prem asks, how can coastal access laws and policies support community-led conservation, such as, say, traditional fishing or marine mammal stranding responses, without imposing undue risk on communities or intertidal ecosystems?
Yeah, that's a good question.
A lot of complicated things in there, but
Yeah,
the issue of risk is an interesting one.
yeah. Um, I mean, yeah, when I think about risk from a legal perspective, I think about like liability and liability to whom. I mean, there's lots of instances in Nova Scotia. I mean, we talk about the Anglers Act, but there's lots of informal agreements between private property owners and community members or fishers, individual fishers, or just the public at large even. I actually live on the Margaree River in Cape Breton, which is a famous salmon museum, and I've had people just cross my field, my yard, and go fish. And so we have this tradition, and then I mean, I've heard this in lots of workshops in Atlantic Canada. What is my risk as a property owner then? If I'm just allowing people, I'm not putting up signs. If I'm allowing them onto my property or to cross my property, what is my risk to me if they get injured or they destroy something or they cause damage to the environment? What is my risk? So that's certainly something, and I think it's just about having those conversations. Like, not everything has to be a policy or law. Lots of agreement just comes about as like, hey, can I walk in your property? Yeah, go ahead. You're not going to then have liability as a property owner if suddenly someone, takes an ATV and starts charging up and down the beach and causes damage. You haven't agreed to that. You've just agreed to allow them to cross your land. So just having informal conversations is always a good one to kind of minimizing that risk. Just have that conversation. I mean, The other thing about access is there, I mean, there are cases where access is about limiting access, like laws are about limiting access to spaces. For example, some prudential parks are about creating access. Some are about protecting those same spaces, preventing people from accessing. So the flip side to coastal access from a legal perspective is limiting access, and thereby limiting the risk to those ecosystems that are really important. And then obviously coastal access is also really important for research and restoration projects. For example, if you want to restore eelgrass meadows along the coast, well, you have to get to the coast. And sometimes being able to get to a wharf and get on a boat and go all the way around is just not a feasible thing to do. And so these are all conversations we really need to be having more of, which I think is the point of this symposium. So there's no good answer. I'm sorry, I can't give you a good answer.
Come on, that's why we brought in the lawyers at the beginning is where's the answers? Oh, I'm kidding. Yeah, thank you so very much for your talk and for sharing some of those insights this morning. Really appreciate you kicking us off today.